Good morning, ladies and gentlemen. Welcome to the side event under the title Environmental Injustice, Exploitation of Palestinian Natural Resources. Thank you, everybody, for coming to this event and joining us today. We are very happy to have with us two distinguished speakers. The first of our speakers is Michael Link. He is Associate Professor of Law at Western University, London. He has worked for the United Nations on Human Rights and Refugee Issues in Jerusalem, and now he is the United Nations Special Rapporteur on the situation of human rights in the Occupied Palestinian Territories. His report, presented to the Human Rights Council this session, focuses on the obligation of the occupying power with regards to natural resources, especially water. The report finds that Israel is violating its obligations in many aspects, and he will present his findings to you. Thank you very much for being here with us, and you have the floor.
Thank you very much. Okay. It's a great honor to be asked to be part of this side event at the United Nations, and particularly the chance that it gives me to be able to highlight some of the findings in my most recent report, which was delivered yesterday to the Human Rights Commission. Let me give you some of the highlights with respect to my report, which focus on water, natural resources, and the environment. A cluster of Palestinian villages in the South Hebron Hills have had their newly laid water pipes, which have finally brought them clean running water, destroyed by the Israeli civil administration, forcing them to buy expensive trucked-in water for their homes and animals. In Gaza, the collapse of the coastal aquifer, the only natural source of drinking water in the Strip, and now almost entirely unfit for human consumption, is contributing to significant health crises among the 2 million Palestinians living there. Throughout the West Bank, Israeli quarry companies expropriate approximately 17 million tons of stone annually, almost all of which is destined for the Israeli local market, notwithstanding very strict prohibitions in international law against the military power economically exploiting an occupied territory. The Dead Sea and its plentiful natural resources, part of which lies within the occupied Palestinian territory, is off limits to any Palestinian development, while Israeli companies are permitted to harvest the minerals in an apparent act of pillage. Groves of West Bank olive trees, which are both an economic wellspring for thousands of Palestinian farmers and a symbol for Palestinian identity, are routinely destroyed by Israeli settlers with virtual impunity. The transfer of Israeli industrial waste to treatment plants in the West Bank through the creation of so-called sacrifice zones, which are less rigorously regulated, contributes to the environmental scarring of the occupied territory without the involvement or the consent of the Palestinians. For almost 5 million Palestinians living under occupation, the degradation and alienation of their water supply, the exploitation of their natural resources, and the defacing of their environment is symptomatic of a lack of any meaningful control they have over their daily lives as Israel, the occupying power, exercises its military administrative powers in a sovereign-like fashion with vastly discriminatory consequences. All peoples, including peoples under occupation, enjoy the sovereign right to control their natural wealth. And international law strictly regulates what an occupying power may do with the resources of an occupied territory. Yet the Israeli occupation, with its appetite for territory and settlement implantation and its sequestration of natural resources, has become virtually indistinguishable from annexation. So this is the introduction to my report. I briefly want to mention what are the main features with respect to international humanitarian law that wind up governing this particular regime. First of all, an occupying power is entitled only to a limited use of the public natural resources of the occupied territory. It's very clear in Article 55 of the 1907 Hague Regulations, which stipulate that the occupying power, and here I quote, can only act as the administrator and usufructuary of the public immovable property of the occupied territory. Flowing from this Therefore, the occupying power must safeguard the capital of these resources according to the principle of conservation. Accordingly, the occupying power has no legal authority to exploit any of the resources and property on the territory for the benefit of its own economy. And to be very clear, the purpose of this rule is to remove any incentive for the occupying power to act in a predatory or avaricious manner towards the occupied territory and its wealth, thereby discouraging war and prolonged alien rule. The second point in law is that the occupying power is absolutely forbidden under the Fourth Geneva Convention of 1949 to transfer any of its civilian population into the occupied territory. According to the Rome Statute of 1998, this is a war crime. This rule is meant to eliminate the temptation of annexation and colonialism. One of the inevitable consequences of transferring a civilian population is the occupying power's requisition of the territory's natural wealth to sustain this colonizing population. In such circumstances, this wealth is invariably appropriated in a deeply discriminatory fashion to the detriment of the protected population. And third, the occupying power's duty to act as trustee towards the protected population would include the obligation of good governance. Among other things, this obligation would require the occupying power to safeguard, to the extent possible, the ability of the protected population to enjoy at least an adequate standard of living, including all of the necessities for personal and economic life, environmental conservation, and the sustainable use of natural resources. These principles of trusteeship and good governance would incorporate the duty to preserve and protect the territory's natural wealth in preparation for the expeditious end of the occupation and the full restoration of sovereignty. The trustee and good governance principle would also include the strict prohibition against discrimination. So when you use those principles of international humanitarian law, and there are additional principles that you find in international human rights law, when we apply that extensive body of law to the actual operations of the 51-year-old occupation of the Palestinian territory, I use that body to be able to examine what is happening in particular to water, but also to natural resources and the environment as well. So I'm going to skim through some of this in the interest of time to let you know what my particular findings are. With respect to the West Bank, although the Oslo agreements of the mid-1990s, which Israel and the Palestine Liberation Organization signed to develop which devolved some governance powers to the Palestinian Authority, Israel did not relinquish its primary domination over the waters of the West Bank. For the purposes of this report, the Oslo Accords signify three particular developments. First of all, as many of you might know, the Oslo Accords from the mid-1990s created three separate areas of control in the West Bank, with Israel exercising overall security control over the entire territory, and the Palestinian Authority exercising nominal civil control over 40% of the territory of the West Bank, and within that, nominal security control over only 18%. In the Area C, which consists of 60% of the West Bank, as most of the fertile agricultural land, Israel has exclusive civil and security control. All of Israel's about 220 settlements and 400,000+ settlers in the West Bank are in Area C, which also contains the majority of the agricultural lands, the water resources, and the underground reservoirs of the occupied Palestinian territory, to which the Palestinian Authority has very little access to. The second feature of the Oslo process is that under Article 40 of the interim 1995 interim Oslo Accord, it provided that Israel would recognize Palestinian water rights in the West Bank. However, these water rights were not defined. The allocations of the waters from the main mountain aquifer, which is the main source of water in the West Bank, under the 1995 Accord, was overwhelmingly in Israel's favor. Israel was to receive 80% of the waters, and the Palestinians only 20% of the waters under that accord. Under Oslo, the Palestinian Authority acquired some powers to manage water, but only within areas A and B. Most of the infrastructure for water acquisition and development happens to lie in the Israeli-controlled Area C. While the Oslo Accords were designed to last only till 1999, they remain in this place today, 20 years later, and their inequitable water arrangements have actually widened. In 2014, it was estimated that the share of the water aquifer waters was 87% for Israel and 13% for the Palestinians. And the third major development that came out of the 1995 Oslo Accords was that there was the establishment of the Joint Water Committee, the JWC, made up of an equal number of designated water officials from both Israel and the Palestinian Authority. The committee is authorized to regulate water and sanitation in the West Bank, including granting permits for drilling, wells, and for extracting water. However, as the World Bank has noted, the committee has created an effective Israeli veto over any management measures and infrastructure projects proposed by the Palestinian Authority. As well, the World Bank observed, and here I'm quoting, that the Israeli territorial jurisdiction in Area C consolidates this control, which has made integrated planning and management of water resources virtually impossible for the Palestinian Authority. In 2012, the committee actually stopped meeting for 5 years because the Palestinian members were no longer willing to accept the Israeli insistence of a quid pro quo arrangement, which saw the approval of Israeli water projects to service the Israeli settlements in exchange for approving some Palestinian water projects. The committee resumed its work in 2017 with modified approval procedures. The Palestinians can now lay water pipes and networks without committee approval, but as well, Israel can develop its own separate water system for the Israeli settlements without committee approval. What remains constant, according to water expert Jan Selby, who teaches water management in England, are and here I'm quoting, the widening water inequalities as the West Bank has become progressively more dependent on Israel for its water supplies. Although Palestinians now will have autonomy to lay pipes, what they won't have is any additional water to go in them, except with Israeli consent. And I should point out to you, for those of you who may not be familiar with the area, that you often hear of water shortage in the Middle East, and that's true for many, many areas. It's not true for the West Bank. Indeed, Ramallah, on an annual basis, receives more water rainfall than London, England does. So what I would want to point out is that what remains now is a significant water disparity between Israelis and West Bank Palestinians in their access to and their consumption of water. A recent estimate found that the residents of Israel and the Israeli settlers consume approximately 3 times as much water per person per day, around 250 liters per day, as do West Bank Palestinians at around 84 liters per day. According to B'Tselem, the Israeli human rights group, the Palestinians are currently extracting only about 3/4, 75% of their share of water, as specified in the Oslo Accords, which was 20% of the total aquifer, notwithstanding the fact that the Palestinian population in the West Bank since 1995 has almost doubled. This is due to several factors, including the technical failure of new drilling and administrative obstacles erected by Israel, including lack of permission for replacing older water pipes and drilling wells in Area C. As a result, the Palestinian Authority has to purchase significant amounts of water from Mekarot, which is the Israeli Water Authority, much of which has been extracted from the mountain aquifer within the West Bank. So the Palestinians are having to purchase their own water from their own mountain aquifer from Israel, which is to be returned to them. And when summer droughts occur, Palestinian communities which are connected to the Mekarot network often suffer lengthy water outages, while remaining settlements are largely spared any significant water reduction. Let me just turn very briefly in the last part of my remarks then to the issue of water in Gaza. Gaza's water crisis situation is a crisis verging on a humanitarian catastrophe. The United Nations estimated in 2017 that more than 96% of the coastal aquifer groundwater, which is Gaza's sole source for natural water, has become unfit for human consumption, and the aquifer would be irreversibly damaged as a drinking source by 2020 without a radical intervention. Gaza has been brought to the brink by multiple factors, including its increasing population, the increasing over-extraction of its source aquifer, the substantial contamination of the aquifer by sewage and seawater, a feeble and steeply shrinking economy coupled with extreme poverty, and the regular destruction inflicted on its water, sanitation, and energy supply systems by Israel through its various military campaigns since 2006, as well as by Israel's suffocating blockade, including the restrictions that it imposes on the import of dual-use items such as water pumps, spare parts, pipes, and purification chemicals. About 86% of Gaza's water supplies are pumped from the aquifer. Keep this in mind, in 2000, the public water network in Gaza provided over 98% of Gazans with safe, drinkable water. By 2014, that figure had plummeted from 98% to about 10%. Most Gazans, and over 60% of whom are food insecure, and over 55% of whom are unemployed, now rely on very low and medium quality trucked water that is somewhere between 10 and 30 times more expensive. While the annual cost in Western countries is at less than 1% of our monthly wages for water, a third of the monthly wages of Gazans goes towards the purchase of water for those who can't afford it. This water crisis in Gaza is now causing a serious public health danger for its inhabitants. The lack of a secure power supply in Gaza because of a war-damaged power plant, a chronic lack of fuel to operate what remains of the power plant, and insecure external sources has meant that Gaza's waste treatment system functions poorly, if it functions at all. This results in the discharge of 110,000 cubic liters of partly or entirely untreated waste daily into the Mediterranean Sea. More raw sewage is collected into unstable lagoons and waste pools in Gaza, which often leaches into the subsoil and the aquifer. All of this results in very high levels of nitrates, chemicals, and chlorine in Gaza's waters, which contributes to the threat of waterborne diseases. According to a report released in October 2018 by the RAND Corporation, more than a quarter of all reported diseases in Gaza are the result of poor water quality and remote water supply access. It also noted that water-related diseases are the primary cause of child morbidity in Gaza. The solutions for Gaza's water crisis are both technical and political. A large desalination plant is planned for central Gaza, but still requires substantial international funding for construction and would only be able to meet a small portion of Gaza's water needs. Rehabilitating Gaza's power network to produce reliable and affordable electricity to enable the desalination plant's construction and operation, to be able to build, repair, and operate sewage treatment plants, to revitalize the Gazan economy, and to provide steady power and water to homes and workplaces is absolutely essential. Major investments in solar panel farms would be economically beneficial, environmentally sustainable, and supportive of a master plan to restore Gaza's water sources. But, as a recent study, this is in 2018, in the British medical journal The Lancet said, occupation and siege are the primary impediments to the successful promotion of public health in Gaza. Until Israel entirely lifts its blockade of Gaza, and until Gazans can exercise their freedom of movement and their right to development free of occupation, even the most imaginative technological solutions to Gaza's water crisis will always be susceptible to the vagaries of a lopsided power relationship and asymmetrical war. If I can just briefly mention the fact with respect to natural resources, one issue actually I will just mention in brief because I know my time is running short and we want to hear from Elford as well, has to do with the issue of quarrying. There are a number of quarrying pits and operations in Gaza. Quarrying would be a natural resource belonging exclusively to the Palestinian people as part of their natural wealth and resources under international law. But Israel, as the occupying power, has permitted mining concessions to 10 Israeli-operated quarries in Area C of the West Bank. According to Yashtin, another Israeli human rights group, the volume of quarrying has increased substantially in recent years, with the production reaching 17 million tons, as I mentioned before, in 2015. Approximately 94% of the production in these Israeli-owned quarries, which produce stone, gravel, and gypsum, is shipped to Israel for construction and infrastructure purposes. These West Bank operations make up between 20 and 30% of Israel's annual quarrying requirements, with royalties paid to the State of Israel. In 2011, Yashtin challenged the legality of Israel's quarrying operations to the Supreme Court of Israel. In a ruling which reflects the ritual of the Israeli High Court to provide legal permission and legal sanction for many aspects of the Israeli occupation, the Israeli Supreme Court dismissed the petition. The court held that the 1907 Hague regulations allowed for economic development and normal life under occupation, but without doing any distinction whatsoever between the interests of the protected population, the Palestinians, and the prohibitions against economic exploitation by the occupying power. According to Michael Safard, an Israeli human rights lawyer who fought the case on behalf of Yashtin, the Israeli Supreme Court ruling in the quarry case, and here I quote, transforms limitations on the powers of the occupant to exploit the natural resources of an occupied territory into an authorization to advance the very colonial enterprise they were set to eliminate. Am I allowed to have a brief conclusion?
Yes.
Okay. So, my conclusion is this, is that Israel has strayed extremely far from its legal responsibilities as occupying power during its administration of its 51-year-old occupation of the Palestinian territory. Indeed, its temporary permanent occupation of the Palestinian territory has been the photo negative of what is required of a faithful occupying power. During its 5 decades as occupant, it has expropriated private and public property without lawful authority. It has regarded the Palestinian territory as its own for acquisitive purposes and someone else's territory with respect to who protects the people under occupation. Its expropriation of Palestinian hydro resources breaches both international humanitarian and human rights law and scorns the principle that underlies the right to water. Its usurpation of the territory's natural resources and its disregard of the environment robs the Palestinian of vital assets that they require should it ever achieve its freedom. The right to development in Palestine, I suggest, has become a dead letter. Can we not do the math to understand that these realities belie any visible path to Palestinian self-determination and instead lead to a darker future which portends dangers to both people? Thank you very much.
Thank you very much to Michael Link for his report and this excellent presentation. Although, of course, it's very concerning. The findings are very concerning. And I would like to add just some personal words also in this context. As a former human rights officer with Geneva International Center for Justice and also as a current peace expert for Palestine, I've been following the situation on the ground since many, many years. And from what I've seen with my own eyes, I can just confirm what Michael here just said. I've seen Palestinians standing next to their water well and had to demolish it because it was illegal construction. Meanwhile, the settlement next door is fully connected to water. So the discrimination. I've witnessed the takeover of houses by settlers. I've been attacked by settlers. I've been on the spot when there were demolitions, closures, humiliation, arrests of people. And I've really also been deeply disturbed to see Israel expand its control over all aspects of Palestinian lives and with little intention of granting them any rights. If you really talk to people also inside Israel, you have the feeling for them Palestine doesn't exist anymore. more and more politicians call for total annexation of Area C, which is 60% of the West Bank. If you drive through the West Bank, you can by now see the signs. It's only just a road. And if you want to Area A, Palestinian control, go left and right, but that's not Palestine anymore. And I would just like to quote an example with an encounter with a woman on a Christmas market in Jerusalem that I had once. I told her the story of one of our women initiatives in Palestine and the products they produce. And she referred, like many Israelis do, to the West Bank as Judea and Samaria. And I just nicely corrected her and said, we are still talking about Palestine. And she said, well, that was once before. So this is just to illustrate the spirit of annexation. With this, I would like to give the floor to Mr. Alfred de Zayas, who is the former independent expert on the promotion of a democratic and equitable international order. We are very honored to have you with us today, and I'm looking forward to we are all looking forward to your presentation.
Thank you, Daniela. Well, I suppose most of you know me. I'm an ex-rapporteur, 2012-2018. And I wanted to say I always learn a great deal when I listen to Professor Michael Link. And as I maintain actually quite a few personal and epistolar contacts, both with Richard Falk and with John Dugard. And it is kind of sad to have to accept that we rapporteurs and former rapporteurs are in a way an assembly of Cassandras who are indicating where the problems are, formulating the possible solutions, and then the governments do not implement anything. As you probably know, there's no follow-up procedure whatever to make sure that what Michael Link puts down in his report as concrete recommendations is actually implemented. So the most you can get is in the UPR procedure that someone picks it up and say, what have you done about the recommendations of Michael Link? But my experience has been that with my 14 reports to the Human Rights Council and the General Assembly, at no time are they being cited in the UPR procedure. I make reference to my 2014 report to the General Assembly on the issue of self-determination. Now, it is obvious to all of you, everybody in this room, that Article 1 of the Covenant on Civil and Political Rights and of the Covenant on Economic, Social, and Cultural Rights not only provides for self-determination for all peoples, obviously including the Palestinians, but also grants sovereignty over the natural resources to these peoples. And this is being stolen today by Israel in the case of the people of Palestine. Now, in this context, and in other contexts actually, I have proposed that in the General Assembly, a resolution be adopted elevating a number of legal questions to the International Court of Justice for an advisory opinion. As you know, already in July 2004, there was an advisory opinion concerning the wall, really a casebook example of a perfect advisory opinion that systematically relates how, just in the issue of the wall, how the Fourth Geneva Convention of 1949 was being violated, how the International Covenant on Civil and Political Rights was being violated, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Rights of the Child. Because obviously the rights of all of these people were impacted by the wall. The ICJ formulated a number of constructive recommendations, which of course Israel ignored and this is now 15 years ago since we have the advisory opinion. Notwithstanding, I think that any peace settlement will have to take into account the law as laid down by the International Court of Justice in that advisory opinion. But a new advisory opinion, a broader advisory opinion, should look at some other legal questions. And I was thinking that it should be possible to get enough votes in the General Assembly to elevate this to the ICJ on the legal consequences of the continued occupation of Palestine by Israel. Everybody will remember the advisory opinion of the ICJ on the continued occupation of South Africa in Namibia, which constituted a violation of Security Council resolutions. Well, here we have clear violations, now a history of 52 years of violating Security Council Resolution 242. And there have been numerous other resolutions. The Security Council tends to make reference to 242, but there's no bite because the United States always puts in the veto on behalf of Israel, and there have never been any sanctions imposed on Israel because of its egregious violation of Resolution 242. So one of the questions to be referred to for an advisory opinion would be, as I said, the legal consequences of this continued occupation. But also, we would need a determination of the level of reparation due to the Palestinian people for 52 years of illegal occupation. We also need a statement, not from us, rapporteurs or former rapporteurs, but a statement from the International Court of Justice about the illegality of the blockade in Gaza and what that entails. Also, whether the theft of the water, the theft of natural resources in Palestine constitutes a crime against humanity under Article 7 of the Rome Statute. Obviously, there are war crimes, and there were many war crimes committed against the people of Palestine. But does it rise to the level of a crime against humanity? And if so, what kind of investigations would be appropriate on the part of the International Criminal Court in The Hague? Would the prosecutor accept documentation with regard to a crime against humanity being committed by consecutive governments of the state of Israel? Beyond that, I would like to see a conference organized to discuss these issues. Everybody, I hope, knows about Norman Finkelstein's newest book published by the University of California Press. The book is just called Gaza. Now, I think that that book documents crimes against humanity. I think that that book deserves a major international conference on this issue, and to bring in not only Norman Finkelstein himself, but also United Nations rapporteurs who have been seized of the issue of Israel. As I said, John Dugard, Richard Falk, Michael Link, but I also think of William Schabas. You remember William Schabas was the head of a commission of inquiry into crimes in Gaza. Also Richard Goldstone. That would give it more visibility, because part of the problem is that notwithstanding what we do here in this room, etc., there is not sufficient consciousness in the United States. When you read the New York Times, when you read the Washington Post, when you hear the news in CNN or in Fox, they are so overwhelmingly biased in favor of Israel and against the Palestinians that more or less the feeling that you get is the Palestinians, it's their own fault. The Palestinians are a bunch of terrorists, etc., etc. This kind of defamation of a whole people. Now, that is a subject matter that I would like to see taken more seriously by our Secretary General, Antonio Guterres, and by our new High Commissioner for Human Rights, Michelle Bachelet. And I'll stop here so that there's time for others. Thanks.
Thank you very much for your comments, and I've really been appealed by you saying that the media is so biased and that there is defamation of a whole people, and especially
rapporteurs too.
and especially today, as we are talking about item 9 in the Human Rights Council, racism. This is something that should speak to all of us. Before we open the floor now for questions, I would like to remind all of us that everybody has the right to agree or disagree with our speakers, with what is said here. However, according to the spirit of the United Nations, we really ask for the discussions to be held in the spirit of mutual respect. For your questions, we would like to take the questions first. If there are comments, we will take them later. I kindly ask you to present yourself. Raise your hand, present yourself, and also keep your question short, please, so we have enough time. Thank you. Could you raise your hand? Yes, we had one. Okay.
Thank you. Hello, my name is Vaughan Raja. I'm an intern with Just Atonement, Inc., and I'm attending the council with a sponsorship from internationallawyers.org. I have a question for Mr. Link. You have noted in your latest report to the Council that it is imperative that all previous water agreements be renegotiated. Given the reality of the current status quo with respect to the parties, what, in your view, is the best way to renegotiate these very agreements?
Let's take a second question, and then is there a second question? Or would you like to answer to this question?
There's a question over there.
I didn't. Okay.
Bonjour à tous. Moi, je suis de l'organisation de l'Alliance internationale AIDEL.
Okay.
En fait, merci pour votre intervention de Monsieur Michael. Pardon?
On regarde s'il y a de la traduction ou pas.
Ah oui.
Il y en a?
Oui.
Okay. Channel 2, you have the translation.
Oui. Je répète, moi je suis de l'organisation de l'Alliance internationale AIDEL qui est située à Paris. Et merci de votre intervention de M. Michael et M. Alfred et Mme Daniela. Et vraiment, ça c'est vraiment une institution qu'on a été. Et on a un dossier en fait qu'on travaille sur le dossier de Palestine. La question, c'est en fait pour les camps palestiniens qui se retrouvent au Liban, à Beyrouth. C'est vraiment une catastrophe, vraiment une catastrophe humanitaire qui se trouve, mais personne en fait qui voit sur ce dossier-là. Moi, j'essaye de travailler, mais je ne trouve pas. C'est qui va m'aider dans ce dossier. Parce que j'étais allée voir en fait sur place, c'est une catastrophe que je ne peux pas vous expliquer comment. Il faut les voir. Moi, j'ai des photos, j'ai des vidéos sur cette situation. Ça, c'est
catastrophic, in particular in Sabra and Shatila camps. And people there...
au secours. Mais il n'y a personne, en fait, qui peut écouter ce message, en fait. Moi, j'ai dit, j'essaye... j'essaye de voir avec
transfer your message
de ce dossier.
Human Rights Council, if you are interested, please tell me if you can help. Is there any solution? Is there any organization that can help my organization to deal with the issue of the camps in Lebanon?
the status of refugees, especially in Sabra Shatila, and what can be done to help them. Itself,
I'm happy to help answer, yes. There's one more, I see a hand down there. Do you want to take a third question and then we can all
Okay,
answer?
let's take this question and then.
أفضل أن أتكلم باللغة العربية.
I will speak in Arabic. My name Omar Khmeisa. I'm a lawyer. I'm the director of Mizan for Human Rights. I'm all the time working with the High Court of Israel, as mentioned by Mr. Mike Link and Alfred when dealing with the decree on 2011 with the Judge Benich giving legitimacy and legal motivation grounds why Israel as an occupying force has the legal power to exploit. The motivation, the explanation of the court of the Hague Convention is not grounded, and this cannot be accepted simply because we have to ask for a consultative opinion as was done concerning the wall. That's why we are calling. I am hoping that we can ask for a new consultative opinion as Mr. Michael Link told and Alfred desires. That's why we are calling and asking for a legal ground. They told us that now this law can no more be accepted because it's more than 40 years. That's why, yes, we as Palestinians, we must to have a new consultative opinion from the ICC to refute and to reject all these judge decisions by the Israeli courts simply because they are exploiting more than 94% of our water. That's why we are calling to have a new legal opinion. Thank you.
Alfred, I'll start if you want me to, and then.
Sure, I'll make a short comment.
Okay,
Yeah,
very
thanks.
good. If you don't mind, I'm going to go backwards, but I'll answer all three of the questions. The most recent question had to do with, I guess, rising from what Alfred had said with respect to the desirability of a new advisory opinion from the International Court of Justice. This is something that I called for in my October 2017 report, in which I examined whether or not Israel was still the lawful occupant of the occupied territories. And I looked at this under four headings. The question of whether or not, but essentially was whether or not Israel is acting in good faith and as a trustee for the best interests of the people under occupation, whether it was obeying the rule that it had to leave had to end the occupation in as short and as reasonable time as possible, and whether it was also obeying the very strict rule against no annexation. And I came to the conclusion in my report in 2017 that it had breached all four of those fundamental rules which govern occupation, and that I was asking for a new advisory opinion to be requested by the General Assembly to the International Court of Justice. And when I raise this issue, particularly with, I must say, official Palestine, they say, look, sounds like a good idea. They say a couple things. One, we still think that the 2004 advisory opinion with respect to the illegality of the location of the separation wall still gives us everything we need. And I say in turn to them, I think that decision gave you a lot 15 years ago, but it's exhausted its potential. It said that settlements are illegal. It said that the location of the wall is illegal. What we don't need now is any further doubt with respect to the legality of the occupation. The world takes the view that the occupation by Israel of the Palestinian territory is lawful albeit there are features of the occupation that are illegal, such as the settlements, the location of the wall, the annexation of East Jerusalem, and so on. My view is that the occupation is now transformed into becoming an illegal occupation. Israel is an illegal occupant. And we have excellent precedential case law for that, which Alfred mentioned in his presentation, which is the 1971 decision by the International Court of Justice on Namibia. So I would like to see a groundswell among civil society to be able to say we need a new advisory opinion from the International Court of Justice. And this, I think, would have the advantage of beginning to crack the ice on this particular conflict. Why? Because if the entire occupation has now crossed the bright red line into illegality, then it changes the obligations, it raises the obligations on the international community with respect to accountability to bring this to a complete end. The second question that was asked had to do with the refugee camps, and I'll be short with respect to that. You mentioned the camps in the West Bank and in Lebanon. I know those camps intimately from former visits both to Lebanon and to the West Bank and to Gaza. And you're right. They live under extremely poor circumstances. They live at the will of international funding, which of course was cut substantially by the United States. Luckily, I understand around 80% of the lost funding that the United States withdrew has been made up by the international community. And in fact, I would say, while the camps in Lebanon and the West Bank and in Gaza are in dire strait, the worst camps of all are the ones in Syria because of the infliction of the war over the last 8 years and what the suffering of the Palestinian refugees there have gone to. And I must say that and certainly this is the case with respect to Lebanon. Lebanon has not fulfilled its obligations under international refugee protection law in providing full rights to the Palestinian refugees in Lebanon to be able to have access to jobs, access to the economy, access to be able to live a full, decent life of dignity in Lebanon while they await their right to be able to satisfy and take advantage of the right to be able to wind up returning. While they are still refugees in Lebanon, while they are still refugees in Syria, they deserve and are entitled to a life of dignity while they're refugee status. And the first question had to do with renegotiation of the water agreements, which I think is an excellent question. The water agreements, the Palestinians probably made a very poor deal in 1995, and they could justify to themselves, I think, at that time, is that these water arrangements, as well as lots of other lopsided arrangements they made at that time, were only going to last until 1999 or at the most 2000, when there would be a final status agreement on all of the outstanding issues. They didn't have any idea, and nor did we have any idea, that 20 years later, after 1999, these outdated, fossilized Oslo agreements would still be trapping the Palestinians into these inequitable agreements. So there should be a renegotiation of the agreements with the thought of giving Palestinians a much greater access to their own water resources and their ability to develop their own water resources. You go to echo what Daniela has said with respect to the West Bank and particularly in the Jordan Valley. There are virtually no permits in Area C given to Palestinians to be able to drill their waters deeper as the aquifer continues to sink into the water, while there are extensive drilling permits given to settlements to be able to drill as deep as they need to in order to be able to access water. The image that Daniela has mentioned, I've seen as myself as well. My very first visit, I remember, in 1981. To the Occupied Territories. I remember going to the Jordan Valley at a time of a drought with all kinds of banana trees grown by Palestinians in the very fertile Jordan Valley, wilting because of lack of water. And I could drive 3 kilometers over to a Jordan Valley settlement, which had a full swimming pool of water for the use of the settlers there. I remember seeing those the last time I was in the Occupied Territories in 2010. Alfred.
Thank you, Michael. Actually, I'm going to be more radical than you I'm going to say that the occupation was illegal ab initio. It was illegal
From the very
ex
beginning.
tunc.
Yeah.
That means if you read Security Council Resolution 242, it says very clearly, it demands the withdrawal of Israel armed forces from the territories occupied in the recent conflict. If you read Resolution 338 of 1973, again, the Security Council is demanding the implementation of Security Council Resolution 242. Now, our problem is a problem of not so much fake news, it's fake perception. It is fake perception of the law, what I would also call as fake law. And Israel is a specialist in promoting fake law and this fake perception. What I wanted to say is that there is a remarkable incoherence in the practice of the United Nations and of the, quote, international community. In 1967, you have a totally illegal occupation of the Palestinian territories, condemned by the Security Council. Nothing happens. In 1974, you have a completely illegal occupation of 37% of the territory of the island of Cyprus by Turkey, the then President Ecevit, condemned by the Security Council. Nothing happened. And then, lo and behold, in 1990, Saddam Hussein dares occupy Kuwait because Kuwait is drilling at an angle and taking the oil that actually belongs to Iraq. In any event, for whatever reason, he occupies Kuwait. That is then condemned by the international community, and they bomb the hell out of Baghdad. They impose grotesque, draconian sanctions on the people of Iraq that caused over 1 million deaths. And that is perceived as normal, whereas an occupation that has lasted for 52 years in Palestine is almost accepted as, oh, well, that's a status quo. I mean, there's nothing to be changed there. I mean, this incoherence, this application of international law a la carte, this application of international law in such a selective manner actually corrupts the whole concept of international law, because international law by definition has to be universal, by definition has to be applied uniformly, and it's not being applied uniformly. But indeed, I agree with Michael on the necessity of elevating all of these legal issues to the International Court of Justice. That is the best avenue we have. That is the highest judicial instance of the United Nations. And it is for the International Court of Justice to decide that the Israeli Supreme Court is deliberately misinterpreting international law. It is manipulating international law. The international law does not say what the Supreme Court of Israel says on these issues. And once the legal framework has been explained, has been laid down by the International Court of Justice, then we have to come to the consequences. And then we depend on the media, and we depend on the non-governmental organizations, and we depend on the activists to demand that change happens. Now, under Trump, no change is going to happen. That we know. With a man, you can't talk. But in 2 years' time, there might be a different president of the United States. We had a president called Jimmy Carter, who had good will, who had good faith, who wanted to see the Palestinians achieve their self-determination, who wrote an important book called Palestine Peace, Not Apartheid, for which he was massively attacked. That he would even suggest that Israel was committing the crime of apartheid, which, by the way, is defined to be a crime against humanity on top of it. So it's not impossible that a new president of the United States might take a different take on the situation between Palestine and Israel. But again, it depends on the level of indignation that the non-governmental organizations and that civil society in general can generate, so that it is quite clear in Washington that there's only AIPAC, and there's only this, shall we say, committed Zionist group in the United States that insists on maintaining and in defending the indefensible.
Thank you very much to our speakers. Unfortunately, we have only 1 minute left. So when I just listen to our speakers, of course, what always comes up is that international law has simply not been applied. There have been double standards in imposing international law also. And of course, this is all related to accountability. Given that now it is 1 o'clock, I would like to thank all of you for having been here. It's been an honor to be here together with you. Also, thanks a lot to our speakers. If there are questions, you are certainly welcome to ask them outside the room. Yeah? Oh, thank you. Thanks a lot.